Yeah, thank you for giving me the opportunity to explain a few things as far as the sugar industry is concerned in Uganda. In light of your first question, you asked and said, what does Ugandan law say about the licensing of sugar mills? Now, Ugandan law is clear. Sugar mills must actually be licensed under the Sugar Act of 2020. The act created the Uganda Sugar Board as the sole authority responsible for licensing and regulating sugar mills. The key point here is that no ministry, no politician, or agency can lawfully license a sugar mill outside this framework. The court have already pronounced themselves, ruled that licenses issued without a proper constituted sugar board are illegal. An example, if for example sugar factory is approved by a letter instead of a sugar board, the approval has no legal effect regardless of who supported it. The other question, how binding is the 25-kilometer rule? Is it a question of law or policy? The 25-kilometer rule comes from the National Sugar Policy, not directly from the Sugar Act. So on paper, it is a policy guideline. However, courts in Uganda have actually made it clear that government must respect its own policies when making decisions. So bottom line, while it's stated as a policy, it has become legally enforceable in practice. So because licensing authorities are expected to follow it unless there are strong lawful reasons not to. Now, the other issue, if mills are actually licensed within restricted distances, is that illegal or even discretionary? It depends on how and by whom the license is actually issued. If it is issued, for example, outside the sugar board, then it becomes illegal. If it is issued without considering the 25-kilometer policy, then it is an unlawful decision. So if it is issued with reasons that ignore sustainability, then it's open to court challenges. So the point that is important here is that the courts have said that discretion is not freedom to act arbitrarily. I will give an example. A regulator, for example, cannot say, we know the rule, but we ignore it. That is not discretion, that is illegality. Now, the other question, do existing millers have legal rights that must be protected? I would answer in the affirmative and say yes. Existing millers have legitimate expectations under the law. How? They invest heavily in these factories. Okay? For example, in terms of outgrower schemes, or perhaps in light of roads and even infrastructure. So when government suddenly licenses a new mill next to it, for example, then it can actually become a question of debate in terms of, uh, destabilizing the cane supply, for example, in terms of collapsing, causing a collapse of the farmer contracts, and also in terms of leading to the destruction of any other earlier investment that may have actually uh, occurred. So Ugandan courts have actually recognized that licensing must protect industry stability, not just simply attract new investors. So constitutionally speaking, we could argue that government has to balance investors and also the farmers. Yes, and in light of that, the constitution basically protects the right to invest and to do business, and the right to work and even earn a livelihood. Yes, and also important is that farmers basically depend on stable markets for their cane. So too many mills competing for the same farmers obviously leads to cane poaching, for example. It could also lead to price manipulation, for example. It could also lead to farmer exploitation. So these have to be taken care of in light of that discussion. So the constitutional balance becomes a very important aspect. Government must actually promote investment without destroying farmer livelihoods or existing businesses, for example. And then the other issue, in light of what you asked, if political pressure influences licensing, does that undermine the rule of law? I would argue and say yes, this does that very directly. How? Because when licenses are issued because of political influence, then there are substantive challenges or effects that will trigger down, in terms of personal connections, in terms of pressure from what? Powerful actors, for example, and not because the law was actually followed. The rule of the law, in effect, would actually collapse if such issues do happen. So courts have also, already, intervened to stop politically influenced licensing because the law must govern, and simply that has to be understood as well. So the other issue is what reforms would prevent future conflicts, for example, in the sugar sector. It's very simple. We could argue in terms of the following. We could argue that fully operationalize the Uganda Sugar Board, and there should be no shortcuts, there should be no ministerial letters, yeah? And then the argument of put the 25 kilometer rule into the law itself, remove the ambiguity once and for all, yes? And then we should also argue in terms of clear public licensing criteria. Everyone should know what qualifies or disqualifies an application, for example, yes? And then we could also argue in terms of mandatory consultation with farmers and existing mile licensing decisions should actually not be made in isolation in light of that. And then you could also argue in terms of strong enforcement against illegal licenses. Yeah, illegal approvals must actually be cancelled immediately. So for purposes of this discussion, I would argue affirmatively and say the sugar problem in Uganda is not about investors versus farmers. It is about respecting the law, following political consistency, and protecting long-term stability of the industry. And that is something I could add in terms of the discussion that we're having today. I thank you.